The following production is presented by League Info Site and the Credit Union Broadcast Experience, QTV.
Hello, I'm Sean Wolbert. Thank you for joining me here at the CU Compliance Connection by InfoSite. This presentation focuses on changes to the garnishment of accounts containing federal benefit payments. The revised final rule was imposed by the Department of Veteran Affairs, Office of Personnel Management, Railroad Retirement Board, Social Security Administration, and the Treasury Department, otherwise referred to as the agencies, to refine established procedures and definitions that credit unions follow when they receive a garnishment order against a member. Current guidance has been in place since May 2011, and the new required changes must be implemented by June 28, 2013. The agencies published the amended rule to address concerns associated with the garnishment of certain exempt federal benefit payments, including Social Security benefits, supplemental security income payments, VA benefits, federal railroad retirement benefits, federal railroad unemployment and sickness benefits, civil service retirement system benefits, and federal employees retirement system benefits. The amendment to the rule created several significant changes to a credit union's review and treatment of garnishment orders. The first changes we need to review pertain to definition changes. The definition of benefit payment has been revised to mean a direct deposit payment that includes not only the XX in positions 54 and 55 of the company entry description field for the ACH transaction, but also the number 2 encoded in the originator status code field of the batch header record of the direct deposit entry. The definition of garnishment order and order are revised to include a levy and also orders issued by states and municipalities, as well as orders to freeze assets. In the past, federal benefit payments have not been protected from those orders, but going forward, credit unions will need to follow the garnishment of federal benefit payments rule when they receive these orders. The official definition now states that a garnishment order means a writ, order, notice, summons, judgment, levy, or similar written instruction issued by a court, a state or state agency, a municipality or municipal corporation, or a state child support enforcement agency, including a lien arising by operation of law for overdue child support or in order to freeze the assets in an account to effect a garnishment against a debtor. The agencies also removed the phrase "to enforce a money judgment" from the definition of garnishment to ensure that the rule is not limited to civil money judgments. The final definition modification of protected amount now refers to the balance in an account when the account review is performed. This change means that the balance will include intraday items such as ATM or cash withdrawals. It's important to note that credit unions should not use the Regulation CC available funds balance when determining a garnishment amount, but should be aware that the requirement to provide access to the protected amount is subject to the usual restrictions on funds of availability under Reg CC. In addition, the agencies do not intend that any line of credit associated with the account be considered a part of the account balance. The Garnishment of Federal Benefit Payments Rule establishes procedures that credit unions must follow when they receive a garnishment order for a member. When a credit union receives a garnishment order, they must first determine if the United States or a state child support enforcement agency is the plaintiff that obtained the order, and if a notice of right to garnish federal benefit payments is attached or included. If so, the credit union follows its customary procedures for handling the order. If not, the credit union must review the account history for the 2-month prior period to determine whether, during this look-back period, one or more exempt benefit payments were directly deposited through Automated Clearinghouse, or ACH, to the member's account. The protected benefit payments deposited through ACH during the look-back period are exempt from garnishment. The agencies retain the provision that funds transferred from one account to another account are excluded from the account review and the establishment of the protected amount. As a part of the revision, the agencies considered this provision and stated that they understand that exempt funds may be transferred to other accounts following the initial deposit. However, requiring the examination of all account transfers after a federal benefit payment has been identified would impose a significant burden on financial institutions. Since they could not be able to rely on the transaction indicator, like the ACH identifier, in searching account histories to determine whether transferred funds should be classified as exempt. Commentary in the final rule also specifically addresses the credit union structure of subaccounts in conjunction with the account review and garnishment. The agency stated that the requirement to perform an account review applies to the deposit account to which a federal benefit is routed and credited. In cases where a payment recipient is assigned a member number that doesn't represent an account per se, but that serves as a prefix for individual subaccounts, it is the individual subaccount where the federal benefit payment was credited, and not the master account that is subject to account review and look-back requirements. The notice requirement for garnishment of accounts with federal benefit payments has also been amended. Credit unions should now issue the required notice when a benefit agency deposited a benefit payment into an account during the look-back period. The balance in the account on the date of the account review was above $0 and the financial institution established a protected amount, and there are funds in the account in excess of the protected amount. The final change from the amended rule allows a credit union to charge a garnishment fee after the date of account review. However, the credit union may not charge or collect a garnishment fee against a protected amount. The agencies decided to amend the rule to provide credit unions with an opportunity for 5 days following the account review to impose a garnishment fee in the event that non-protected funds become available following the account review. If funds other than a benefit payment are deposited to an account during the 5 business days following the date of the account review, the financial institution may charge or collect a fee from those additional funds. Thank you for joining me to review changes to the garnishment of accounts containing federal benefit payments. InfoSite provides an overview of this topic in the Accounts section and guidance on the account review. So for additional information, you should look into this credit union resource. Please stay tuned to the Compliance Connection for additional regulatory reviews and information from InfoSite. I'm Shawn Wolbert with the CU Compliance Connection by InfoSite, only on Cube TV.
Thanks for watching the #1 compliance program for the credit union community. Stay tuned.